From the supplementary list.
With your lordship's leave, may I mention a case, lordship. This case has been dismissed for default for non-compliance of defects, lordship. However, IA had been filed for removal of defect, but the officer did not remove that IA had been filed and it was dismissed, lordship.
After filing the IA, you were supposed to mention it before the court, before the expiry of the
Lordship, that IA had been filed before the passing of order.
maybe before the passing of the order.
Yes, your lordship. And the office did not report that this IA was on record.
You were there in the court when the case was taken?
Yes, your lordship.
Why didn't you indicate?
No, lordship, other defects were there. Lordship had ordered to remove other
Once
defects.
a case is dismissed for default, there is no urgency.
From the supplementary list, under heading for hearing item 1, second appeal 41 of 1997.
कल आपके केस में आप तो वही ऐसा करते हैं, आप लोग बहुत मुश्किल
आप लिखा रही थी तो हम बीच में डिस्टर्ब नहीं किए, लेकिन लास्ट में उनको बोलना चाहिए।
You have already appeared, अब नोटिस जाएगा।
नहीं हम चार के लिए अपील कर रहे थे उसमें, बाकी के लिए जाएगा।
बाकी कितने हैं? आप किसकी तरफ से?
हम हैं सब्स्टिट्यूटेड हुआ था, respondent number 1 substitute।
You will accept notice on their behalf, ना?
हाँ दे दिया। 4 के लिए हो रहे हैं 1C, respondent number 1C, respondent number 2, respondent number 4, respondent number 5।
2, 4 and 5।
जी और 1C।
2, 4, 5 and 1C।
Yes।
ये ना कल एक ऑर्डर लिखाए थे नहीं, हाँ एक ड्राफ्ट ऑर्डर है, इसमें किसने लिया था? विनीत ने लिया। तो इनकी तरफ इनको नोटिस नहीं जाएगा, उसमें दे दीजिए आप विनीत को दे सकते। मिस्टर राजेश कुमार हैज एक्सेप्टेड नोटिस ऑन ये सब हो
केवल
गया।
कॉपी जो है ना वो सब्स्टिट्यूशन का ही हमको मिला था जो नोटिस में
वो
दिया
आप
था।
उनसे मांगिए, आपको मिलेगा।
सेकंड अपील में जाकर
अपीलाइन से मांगिए ना, आप अपीलाइन से मांगिए, दे विल गिव यू।
हाँ
आपके मित्र है ना,
संदीप
दुश्मन नहीं है ना?
संदीप रहता तो कोई बात नहीं था, वो इंगेज है इसीलिए दिक्कत है।
कौन है एडवोकेट ऑन रिकॉर्ड?
हाँ संदीप
आप है ना? बताइए, अपने मित्रों से आप ठीक से बात नहीं करते, कोर्ट से बात करते हैं।
From the supplementary list, under heading for hearing item 1, second appeal 41 of 1997.
Before I begin my reading, I have prepared a short. I must not say short, थोड़ा सा extensive ही है list of dates because it has a checkered history.
There is a substantial question of which order?
The substantial question of law, my lady, is mentioned in order dated 29/4/1998.
You read the substantial
Yes,
question of law?
my lady. Apart from that, there was other substantial questions of law which were also formulated in the body of the second appeal. I'll read the order dated 1998, which refers to the substantial question of law. I'm coming directly to the substantial question of law.
You read the order.
The entire order.
Yes.
Order dated 29/4/1998. Heard the learned counsel for the appellants as also the respondents. This is an appeal against the judgment and decree of the first appellate court by which the judgment and decree of the trial court was reversed in the suit for declaration that the sale deed executed by the plaintiffs number 1 and 2 on 5/4/1975 in favor of defendants is void, inoperative and without it was without consideration, my lady. It is come without jurisdiction, but it is without consideration, the prayer. And after that, the plaintiff number 3 has acquired absolute right of ownership over the property in the suit by the virtue of the sale deeds executed on 15/3/84 and 10/9/85. It appears that the trial court, after framing the necessary issues and after considering the evidence, had decreed the suit by holding that the sale deed dated 5/4/75 was void, inoperative and without jurisdiction. Again, my lady, it should be consideration. However, the defendant filed an appeal against the judgment and decree in which the first appellate court reversed the judgment and decree of the trial court and held that the sale deeds were valid and genuine and could not have been cancelled. Against this judgment and decree of the first appellate court, the present appeal has been filed and it has been contended that the first appellate court could not consider the reasoning of the trial court while upsetting the judgment and decree. It has further been stated that it has to be considered whether the findings of the first appellate court regarding payment of consideration are against the settled principles of law. However, it has been submitted that it has to be considered whether the findings of the first appellate court that the agreement for sale was not an agreement for title and possession and the said agreement has been cancelled by the court below. Some other formulations have been suggested in the memorandum of appeal. However, it appears to be necessary that the appeal should be admitted for hearing in detail apart from what has been stated above by way of formulation. The parties shall be.
So there are two formulations in this order. Whether the finding of the first appellate court regarding payment of consideration are against the settled principles of law, right? And whether the findings of the first appellate court that the agreement for sale was not an agreement for title and possession.
My lady, three consideration. The first one is the first appellate court did not consider the reasoning of the trial court while upsetting the
It has been
judgment and
contended. It has been contended only. Further stated.
It is one of the substantial question of law which has been framed.
It should
हमको
have-
दिया ocean में.
It should have been framed properly, but it has not been done. But I cannot say that once it has been admitted, your Lordship may frame it. I could not get the second question. Honestly,
There is no
even
question,
the
rather.
first
It's a
question
खाली
also.
submission type से है
Yes.
report.
No, my lady.
Subsequently, it has been formulated.
My lady,
There
this
is
the-
subsequent.
Where is
There
the
is a subsequent order as well.
Where is that? So on 24/3/2017, this order has been clarified,
Yes.
Yes.
right?
But that clarification
That is
also.
only mere clerical, whether it was a vendor or the court, that one word has been clarified.
इसमें से तो हमको कोई substantial question of law समझ नहीं आ रहा, but you just tell us what are the substantial
I will
question of law.
I will also take a bit of time today to explain because it has a checkered history. My
No,
lady.
no, checkered history doesn't make any difference. You just
Yes.
tell us what is the substantial question of law.
The substantial question of
There,
law.
it has been framed subsequently also.
My lady, this is
By which order?
This is the order, my lady, and then the order dated 24/3/2017, my lady.
Read it, please.
Yes. Office is directed to delete.
Order number 18.
Order number 18. Office is directed to delete the name of P.K. Prasad from the cause list as the counsel for respondent as he is no more. The appeal was admitted for hearing on 29/4/1998 and substantial question of law was framed on the contention of the learned counsel of the appellant that whether the first appellate court considered the reasoning of the trial court while upsetting the judgment of the decree
All the
regarding.
3 points has been incorporated.
Yes, yes, my lady.
So
I
as
will-
pointed out, there is a typographical error
Yes.
regarding cancellation of by the court due to instead by the vendor. And therefore this order is modified.
Yes.
So this is the substantial question.
Yes.
Got it.
Yes.
May I submit one more thing? Your Lordship, this would ultimately only to save your Lordship's time now.
No.
This is otherwise covered by one of your Lordship's judgment in Pawan Raut case, where the question of limitation would arise. I'm
My
not,
lady, it
I'm
is
not
my appeal. Let
interrupting
me
her.
get an
Yes,
opportunity to argue.
she'll argue. I'll only 2 lines. I'm not. You argue full length. Your Lordship, the agreement, the sale deeds were executed in 1975, and the suit was filed in 1988. In the initial written statement itself, we had taken the specific plea of barred by
What is
limitation.
the finding on the point of limitation
By the trial court said that it was because the suit was not for cancellation, it was only for a declaration that the sale deeds were
Void.
void and therefore limitation would not apply. And the appellate court, despite in appeal, because the trial court had held against us, so we preferred appeal. We took in memo of appeal very specifically these grounds of limitation, but the appellate court does not say anything. But ultimately it reverses the suit and dismisses the suit. So, but this question of limitation would arise, and this is the judgment which was passed by your lordship in second appeal number 493 of 2018, where identical set of circumstances.
In a second appeal, the respondent can also suggest the substantial question of law in court.
My lady,
Permissible or not permissible?
my lady, the point is the issue of limitation was never raised before the appellate court. It was the appellate
No.
court, they
Yes.
moved. They moved before the appellate court. It was never raised. They never
No, let us
argued
see,
it.
let us see.
Yes, my lady. Yes, my
Let us
lady.
see.
Let us see.
Otherwise also point of limitation, the court has to take care of limitations.
I will address on that issue, my
Just a
lady.
moment, just a moment.
Your lordship may,
You just refer to the appellate
Yes,
court's
yes.
arguments.
no, appellate court
My-
finding. Before that, I'll show that I have raised it
Yes,
before the
yes, this
appellate.
is what I want.
Your lordship may kindly take up my appeal, memo of appeal itself, because the appellate court does not discuss, but it ultimately it sets aside the finding of the trial court and
In the arguments of the appellate court.
argument it has not
No,
been.
It has not.
It does not.
No, but specifically in 3 paragraphs, detailed question with regard to how it was barred by limitation that has been taken as a ground. So even assuming, your lordship, that I have not taken, let us assume that it was not there in the written statement, not there in memo of appeal. Then
In the
also
written statement,
the
you say it
Honourable
was there, she does not
Yes,
dispute
yes,
that.
yes. The
Written
Honourable Supreme
statement
Court
there
has
are-
said that this is a question of limitation. The duty is cast upon the court in terms of section 3 of the Limitation Act. So therefore, the court cannot discard this ground only on the ground that it was not raised. It has to consider this question.
It was considered, my lady. That is what my submission is. I will straight away bring my lady to the trial court judgment, which was in my favor. Which was in my favor.
The suit was held to be within limitation.
The suit was within limitation because I am saying because, my lady, what had happened? Brief facts are necessary for explaining my case, my lady. What had happened is the suit is actually filed by the vendor and the vendee. What has happened is this Fateh Mohammed and Ramzan Ali had, and we have never disputed that we did not execute a suit, execute sale deeds in their favor. That was never even disputed. We said that yes, there was a suit. Thereafter, what had happened is since there was no payment of consideration, they executed deeds of cancellation. Thereafter, the brothers executed agreement to sale in favor of plaintiff number 3. So plaintiff,
After executing the sale deed, can a deed of cancellation be executed?
my lady, those are the questions of facts and law which have been appreciated by both the courts. I am not saying it was wrongly or rightly done. But what had happened has happened. There was a recital that I am cancelling this sale deed because I have not received the consideration amount. And on that also they had not acted upon it. There was no suit for eviction or suit for redemption because initially what had happened is this Jamal, the plaintiff number 3 was the tenant in plaintiff numbers 1 and 2's property. So that is from 1966, my lady. Thereafter, what happened? There was a mortgage deed in 1973, which was executed by 3 brothers. This is a issue where 3 brothers are there. Admittedly, one of the brothers was minor at the time when the mortgage deed was there, and it is in the mortgage deed itself, which is exhibited. One of the brothers. Now, by the virtue of this mortgage deed, they come into possession as a mortgagee. Earlier they were tenants and then they were mortgagee. The mortgage interest was transferred to them, basically. Thereafter, what happens? There is execution of sale deeds in favor of this Sandhya Rani Biswas and Ms. Dhamija. But however, what happens? That there is no payment of consideration amount at that time. There was 30-30, total 60,000 had to be paid.
Nothing was paid.
Nothing was paid. Nothing was paid. That is my case, my lady. Thereafter, what happens? They come to a cancellation of deed. The deposition say that I had though informed them, but I had not issued any notice or so pertaining to that cancellation of deed. Thereafter, these brothers execute an agreement to sell in favor of plaintiff number 3. Then eventually over time, this agreement to sell is complied upon bit by bit. They pay certain amount of money, and finally the sale deed is executed in 1985. Thereafter comes our title suit. In the midst, my lady, I must be very fair, Sandhya Rani Bishwas had moved a partition suit in 76, claiming her partition from this because it was an undivided share. It was 1/3, 1/3, 1/3. So the battle is basically for the 2/3 of the property here. That is what has happened. Now the title suit, when I was filed, I prayed for, there was no consideration and the sale deeds were never acted upon. Therefore, it may be declared as void. And since plaintiff number 3 has been in possession as a mortgagee, then after there has been a sale in 1985. Therefore, it may be declared that he is in possession and he has the title, my lady. That is the long and short of the preliminary facts of the case. Now, my lady, I'll come to the judgment of the trial court. I'll read it, my lady.
You show me the point of limitation. Because now the point to be considered,
Yes.
substantial question of law to be considered, has not yet crystallized. They are raising a point. The point number 1 is,
Yes.
can the respondent raise a point of law to be considered in a second appeal?
My lady, then the point of law I can also raise as on fact is.
There is no bar. You can always
My
formulate
lady,
additional
my-
question of law.
Yes.
There is
Their
no bar.
question is of limitation. I will say that their sale deed itself is void because of the
We will-
minority issue.
We will
Yes.
take care of that.
Yes.
It's not that we will not
Yes.
take care of that. Because
Yes.
of minority issue, whether the sale deed is void ab initio or
Yes.
what is the consequence if
Yes.
one of them is a minor.
Yes.
So these things we will take care of. But
Yes.
we can take care of these aspects of the matter only when there is a substantial question of law. Because second appeal has to be confined to the substantial question of law.
That is my lady.
In one of the cases,
Yes.
we had framed additional substantial question of law at the instance of the respondents. First, tell me, do you have any objection to this? We will hear you on that.
Yes.
But we cannot decide it otherwise in absence of any substantial question.
What my proposition in the issue of limitation is, my lady, that the plaintiff number 1 and 2, they were the actual owners of
Your
the property.
proposition argument is later on.
Yes.
But the point is
I am within
whether
limitation.
the point is that whether a substantial question of law is required to be framed as to whether the suit was barred by limitation. What do you have to say to this?
I have 2 legs of argument in this matter. First of all, my lady, the issue of limitation has been determined by both the trial court and appellate court,
Let's see.
even though it was raised.
Let's see, in the trial court we have seen where is the decision in the appellate court?
In the appellate court, my lady,
Where is the decision? Where is the finding of the appellate court on the point of limitation?
there is no finding at all, my
Yes.
lady. There are-
Appellate court is supposed to discuss all the points.
Exactly, my lady. My issue is also that it is supposed to. That has not been done in a lot of issues. Therefore, I am also agreed.
If you want to frame additional substantial question of law, you can also file a petition to that effect. There is no bar. Before we start, you see, at the time of hearing, it is certainly open to you to frame additional substantial question. So firstly, you have to propose that what are the additional substantial question of law you want to argue in this case.
Yes,
Then I
ma'am.
will hear the other side, and then if the court thinks that this is an additional substantial question of law, it will be formulated.
My lady, in my case, my lady, the additional substantial question of law would be the issue of minority.
Okay.
That one of the plaintiffs was a minor at the time when this sale
You
deed
formulate it?
was,
You say? What formulation do you want?
I am saying, my lady, at the time of execution of sale deed, Ramdan Ali was a minor and the same had never been verified by the trial court. There is no,
Verified means? Who
My
will
lady-
verify it?
my lady, the point is it was never an issue before the trial court, neither the appellate court. So The mortgage deed has been declared void ab initio, but I should have been given an opportunity as to produce my age proof as to when the sale deed was
No.
executed.
Where
I
is-
was minor
You
then also.
you show me from the judgments
Yes,
that Ramzan Ali was minor on the date of the execution.
exactly, my lady. That is the issue. It was never adduced before court
If it-
because that
if-
was not an
If
issue.
if a person does not plead
No, my lady.
the point of minority,
No.
was it a pleading?
It was a pleading when the order was it was his deposition in the first order.
डिपोजिशन से नहीं होता है मैडम, प्लीडिंग से होता है। डिपोजिशन में तो आदमी कुछ भी बोलता है।
That is what, my lady. I never claimed minority,
If
even
you
though
if you do not claim minority in your claim, the matter ends. The
but
point
my lady,
is,
it is decided against me at an appellate stage when the minority has been raised. I never had an issue with the minority until and unless they said that the sale deed is valid when it is not. That is the problem here. Now the issue of minority I am raising because at
madam,
the
you are
time,
not aware, it appears, that how a second appeal is to be argued.
my lady, I bow down.
The
It may be the
basic-
first time.
The
It may be
basic
my first
idea,
time.
the
I bow
everything
down.
has to be based on the plaint and the written statement.
Yes, yes, of
Right?
course.
You cannot go beyond that.
But
If a
the-
point of minority has not been taken in the plaint or the written statement,
yes, my lady.
howsoever voluminous the evidence may be, and howsoever clinching the evidence may be, it is of no value.
I most respectfully beg to differ, my lady, because the issue was never of minority.
Then you'll have to cite some judgment, and I will decide first this whether any pleading which has not been taken can be taken through the evidence. Let's
My
decide it.
My
You can
lady,
go to the Supreme Court against that, and then we will decide the second appeal.
my issue here, what I'm not able to place myself properly.
No,
in
it's
the
very
second
clear,
appeal.
madam. It's very clear. One line.
Yes,
The pleadings, the entire case has to be based on pleadings. If no such pleading has been raised on the point of minority, then under such circumstances, any evidence on that will not say,
my lady.
unless you amend the plaint.
The minority in question is admittedly in the mortgage deed. That
I
I
will
was
not
a-
read it from there.
I'm placing my
You
lady
will
have
not
a
read
bit
it
of
from there.
patience with me. I'm coming.
I am very patient.
Yes. So
You
it was
just
pleaded.
you just tell me that can any evidence be led beyond the pleadings?
My lady, evidence is a part
Madam,
of pleadings.
you get prepared. We just
No,
can't
I am
enter
prepared.
into an argument of this nature where you are not aware of the basic rules of pleadings and the evidence.
My lady, that is what I am saying, that the
No.
evidence for the minority
No,
had never been adduced.
whatever you have to say, whatever additional point of law you want to argue, you have to put it on affidavit by way of at least a counsel would prepare it and put it on record, and then only I'll consider it. Mr. Rahul, you can also suggest whatever you have to. You
My
also put
lady,
it in writing.
Yes.
You exchange amongst yourself.
We can
Prepare
do
yourself
Yes,
on every
absolutely,
point,
absolutely.
and you have to also point out the provision of law under which you, at your instance, also any substantial
Yes,
question
yes.
of law can be framed. Please do it. We don't have time
We
for
can
all
have
this.
fresh,
No.
a substantial question of law, not an issue, my lady.
Sorry?
Because we can probably have a fresh substantial, we'll
No,
exchange our-
you do it.
we'll
How much time
exchange.
do you need to do this?
My lady, I'll require 2 weeks.
Essay number 41 of 1997 within bracket R. Learned counsel for the parties are present. Both of them have submitted that certain substantial questions of law arise in this case, which is required to be considered. They submit that they will file an appropriate petition to that effect. दोनों जने फाइट करिए दोनों को सुन के ऑर्डर और अपने
Only
को
one
तैयार
submission.
ऐसे हम लोग कोई
हमने
ये
वो नहीं बोल
कोई
रहे हैं।
एकेडमिक
ये-
डिस्कशन में नहीं पढ़ सकते
ये बार आएगा इसलिए आई एम सबमिटिंग दिस ये रुचि whether a respondent can propose a
ये
substantial
उस दिन तो
question.
कुछ प्रोविजन ऑफ लॉ देख के बनाए थे अब भूल गए
103 था and this was pointed out by Mr. Sinha. Not take credit for that. Now only one thing, as a respondent, if the ultimate decree is in my favor by the appellate court and I am the respondent, then I cannot prefer a separate appeal.
That's right.
So what I can do in order to
You
support
see,
the
prima
ultimate
facie, I am of the view that once you have raised a plea of limitation,
yes.
and if it has not been considered by the appellate court, although you have won the case, then it has to be framed.
Yes,
but she has to be given an opportunity to respond to that.
Yes.
Therefore, you file your
Yes,
petition.
absolutely.
And for her petition also,
Yes.
you prepared it. And madam, please educate yourself as to whether any evidence beyond the pleading is permissible under law.
My lady, I'll cite judgments to that.
You cite, you just whatever you, whenever you file your petition, you just annex the judgments also along with that. We'll see.
My lady, a date may be fixed.
Date is always there. When do you want?
Sometime
It may be fixed according to.
हमारे यहाँ 1 सेकेंड अपील पढ़ेंगे ना लाइफ टाइम के लिए तैयार हैं.
No,
This much I can tell you.
my endeavor is that I am standing before stalwarts of civil litigation. This is my
No, you will become a
opportunity.
stalwart by the time you finish
This is my
litigation.
opportunity. I'll cite judgments to that effect and we'll frame fresh.
Silently आपके favor या against में order नहीं करेंगे.
नहीं, I don't even.
ठीक है, that will never happen in this court. I don't file pass orders silently कि कुछ भी हमको मन में आया एक order कर देंगे, ऐसा नहीं करेंगे.
Because while going through the documents,
basic of civil law is whether you can adduce any evidence or refer to any evidence which is beyond the pleadings. Work on that. That will be required to be worked.
Yes.
my endeavor was, my lady, actually that this issue has been decided against me raising minority, and my minority was never in question in trial court.
So that's
That
right.
is the issue.
So you have to frame an issue whether the court could have gone into this issue or not.
Exactly.
आप उल्टा समझ रहे हैं.
Exactly.
Whether the court could have gone into the issue of minority when it was nobody's case
Yes.
in the plaint and the written statement.
Exactly.
ऐसा करके frame करिए. Then let me see what do they answer to that.
And
Okay.
see the limitation portion also.
Limitations.
And see.
और वो judgment में इनको बताइए कौन सा judgment
हाँ,
पर आओ.
Let me be educated by my
बता दे
seniors.
It is passed by your lordship. It was passed by your lordship. I am giving it to her.
कौन सा ऐसे नंबर?
Second appeal number
493 of
2018. Absolutely identical case where registered deed was there. It was cancelled by the person who had executed, and then after 33 years in that, she filed a suit. And in this case, after 18 years of the registration,
Not
So-
18 years.
No, whatever it is beyond 3 years तो है ना.
beyond 3 years.
No, within 3 years. For plaintiff number 3 and plaintiff number 1 and 2
अच्छा,
were
कोई बात
already the owners.
Plaintiff,
This will be on the merit of the limitation.
Whether the issue of limitation can be decided as of now when it has already been decided by the learned courts below. The
Only
final-
one court has decided it. Right. Appellate court has not gone.
Had not touched it. Appellate court has not touched on many things. That is why we are here.
Date बताइए आपको कौन सा date चाहिए?
18th maybe.
Okay. जो आपको मन whatever suits you. 18 September.
18th, 19th. It may be fixed or at 2 maybe. Is
ऐसे
possible.
time भी कर सकते हैं. You come.
Under heading for orders with effect, item 2, SA 157 of 2018.
Appellant? Why is he not appearing? कल भी नहीं आए थे. FA number 157 of 2018. Nobody appears on behalf of the applicant. Time till 19th of September is granted to the applicant to remove the surviving defects. Thank you. If the defects are removed within time, pose this case on 23rd September in the supplementary process.
Item 3, SA 174 of 2018.
Same order.
Item 4, FA 8903 of 2024, filing number.
इसका तो करेक्टेड कॉपी ऑफ द डिक्री आ गया है ना. देखिए, FA फाइलिंग नंबर 8903 of 2024. ये देखिए कॉन्ट्रडिक्टरी नोट है. बुलाइए जरा इनको जो नोट बनाते हैं. सर्टिफाइड कॉपी ऑफ द डिक्री में अवार्ड वैल्यू इसमें है तो पीछे देखिए, दिखाइए जरा, बुलाइए. नेक्स्ट केस वन.
From daily list and heading for final disposal, item 1, second April 94 of 1993.
Whom are you representing? Respondent.
9, 10 and 12.
Who is for the appellant? इसका नाम
Mr. Amar Kumar Singh.
ये अबेटमेंट नहीं है ना इसमें?
We tried to contact but no one has submitted तो ही क्या होगा सब पुराना है
नहीं नहीं, मतलब ऐसे रिकॉर्ड पे तो कोई ऐसे
रिकॉर्ड पे तो
abatement
कोई
नहीं है।
कंडीशन नहीं दिखा
Respondent number 1 was expunged. 1A, 1B, 1C. चलो। इसमें जरा एक चीज देखिए, ऑफिस नोट में दे आर रेफरिंग टू 2 ऑर्डर्स, एक 6/6/2011 and 10/1/2012. So 6/6/2011 का सब्स्टिट्यूशन अलाउ हुआ है, दूसरा है 10/1/2012। ये कैसे इस तरह से ऑफिस नोट, इन लोगों को बहुत ज़्यादा ट्रेनिंग की ज़रूरत है भाई, दिस इज टू मच। 10/1/2012 का तो कोई ऑर्डर शीट ही नहीं है। छोड़ दीजिए, इसमें दिमाग में जरा सा, लेकिन इनको जरा बोलिएगा इसका क्या मतलब है।
जी
रेफर टू सच एंड सच ऑर्डर, उसका क्या क्या डेरिवेटिव है, क्या मतलब, क्या बोलना चाहते हैं, कुछ नहीं लिखा हुआ है।
स्पेसिफिक
तो?
देखना चाहिए था।
Who has made this? कौन है ये? कौन है?
डीए है, बुला लो।
उनको बुलाइए, और साथ में ये आपके सेक्शन ऑफिसर को भी बुलाइए, जो भी हैं इनके,
जी
उनको ट्रेनिंग कराइए।
ठीक।
इस तरह से ऑफिस नोट नहीं बनता। हाँ चलिए, लेट्स सी द सब्सटेंशियल क्वेश्चन ऑफ लॉ, रिकॉर्ड कीजिए।
While order dated 1/12/1994, the second appeal was admitted.
एग्जिबिट
Order
1।
number 8.
पढ़िए पढ़िए।
Whether the court of appeal below was heard in law in interpreting Exhibit 1, whether the court of appeal below heard in law in holding that Exhibit 1 was a deed of gift rather than memorandum of family arrangement, whether the findings
ए एंड बी आर द सेम,
one
सेम है ना दोनों?
A अभी नहीं कही है, केवल only for Exhibit 1 it has been.
हाँ, दोनों तो सेम ही हैं,
हाँ,
पहला और दूसरा क्वेश्चन। यस, आगे।
whether the findings of the court below that the defendant respondents are residing in the suit formation as owner is sustainable in law, whether in view of the findings of the learned court below regarding jointness of the properties, the defendants who are strangers to the family have acquired a title over a specified portion in the joint property, whether in view of the evidence of the Santosh Big, son of Gauri Prasad, the suit of the plaintiff could have been dismissed.
ये कौन है? पीडब्ल्यू
This one is the
संतोष कुमार
it
बीडीएस।
is Gauri Prasad. The defendant claims that they have purchased the property from Gauri Prasad, which has to be challenged that it is not sold by Gauri Prasad. Now Gauri Prasad with family member came, son came, and he specifically given evidence that neither my father nor I have ever sold the sold property to the defendant.
Okay, he was examined as
As one of the PW's member.
पीडब्ल्यू। पीडब्ल्यू नंबर
Yes, yes.
एग्जिबिट 1 निकाल दीजिए।
PW1 is valid. Santosh Kumar B.
डीडब्ल्यू 1 और पीडब्ल्यू 1।
He is PW1. PW. 3W1. And his evidence is very much important material, my lord, because this 3W1 is aged about 70 years. In the year, my lord, 89.
Let's see the foundational case and then we'll come to the
Right.
substantive. Trial court first. Refer to the prayer, case of the respective parties, issues and the findings.
Yes. The suit 302 of 1985 was filed by Dhruv Prasad Bid and others. They all are, the plaintiffs are sons of late Kamla Kant Bid.
You read it from the trial court.
Judgment.
Yes.
Late.
No, you read it. इसमें तो कोई रिकॉर्डिंग में एरर नहीं होता है. पुराने जमाने हम देखते हैं प्लेन रिटन स्टेटमेंट सही से लिखते हैं. You want to is there any mismatch?
नहीं, mismatch नहीं.
तो बस आप इसी से पढ़िए ना. फिर सीधे सब्सटेंशियल क्वेश्चन ऑफ लॉ में आएंगे.
My lord, why I am saying, my lord, because party position, my lord, it is very important to see. Anyway, my lord, I am reading. This is title suit 302 of 55. This suit has been filed and this has been decided, my lord, by learned subject 350. This suit has been filed by the plaintiff for declaration of their title over Schedule A and B property and for recovery of possession after evicting the defendants from the suit property Schedule B. The plaintiffs have further paid for cost of the suit. The plaintiff's case briefly stated run as follows that the plot number 2218 under Khata number 732 area 0.1 decimal and plot number 2219 under Khata number 732 area 0.07 decimal was at all material times held and possessed by Suraj Narayan Bin, the grandfather of the
just पता चला. सूट वैल्यू दिया मैंने उसमें.
वो तो आई एम लाइक उसने कहा मेरे से कि वो जो अवार्ड भी लिखा हुआ था और सूट वैल्यू भी करते हैं.
जो अवार्ड वैल्यू लिखा वैसे कोई फर्क नहीं पड़ता. सब वन एंड द सेम थिंग. इट्स वन एंड द सेम थिंग. सूट वैल्यू अवार्ड वैल्यू.
ये वाला जी सब कुछ कंप्लीट है. ये रेफर कर रहे हैं कि ऑर्डर भी रेफर कर रहे हैं उनको भी आता है.
उनका ट्रेनिंग है. हाँ यस प्लीज कंटिन्यू. Possessed by common ancestor is
Suraj, yes, he is common ancestor.
read it please.
Suraj Narayan Bin, the grandfather of the plaintiff, Suraj Narayan Bin, died leaving behind 5 sons, Gauri Prasad Bin, Ram Bin, Banwali Bin, Kamla Kant Bin and Anand Prasad Bin. Gauri Prasad Bin died leaving behind 1 son, Santosh Kumar Bin and 3 daughters. Ram died leaving behind 3 sons, Badan Chand, Ajit Chand, Raju Chand and a widow who is suffering from leprosy. Banwali Bin died leaving behind the plaintiff being his sons, 2 daughters and the widow. The daughters and the widow have not been included in their as their suit is being filed by the plaintiff for themselves and on behalf of the said daughter and widow. Anand Prasad Bin died bachelor. Suraj Narayan Bin during his lifetime wanted to arrange his property in such a way that after his death there might not be any dispute among his sons with regard to the properties. Accordingly, this new property was in a natural family arrangement allotted to Kamlakant Bid, and a document was drawn by Susnaran Bid and all five sons by which the allotment of this new property to Kamlakant Bid was acknowledged and confirmed on 5/8/1934. Kamlakant Bid was in possession of the suit property. He however permitted some of his brothers to reside in the house over the suit property. The possession of the said brothers was permissive. The further case of the plaintiff is that Gauri Prasad Bid and Guhi Ram Bid were therefore had left the suit property and started residing at Etanhatu Banwali Bid also shifted to Tagatoli. After death of Banwali Bid, his son Legan Bid was permitted by Kamlakant Bid to reside in a portion of the suit property. The defendants were inducted as the tenants by Kamlakant Bid in respect of another portion of the suit property. Kamlakant Bid came to know in 1975 that the defendants had applied before CO for mutation of their names in respect of 4 decimal pertaining to plot number 2219 under Khata number 732. Immediately on coming to know of the modified move of the defendants, Kamlakant Bid after obeyed and filed his objection. In the said proceeding, Kamlakant Bid for the first time came to know that defendants are trying to set up a title to the property referred to above on the basis of 2 sale deeds alleged to have been executed by Gauri Prasad Bid in 1962 and Ajit Chand Bid and Badan Chand Bid in 1967. The said sale deeds were forged and fabricated documents and were not executed by the person alleged. The said deeds were without any consideration. The further case of the plaintiff is that even if the person named executed the document titled to the property did not pass to the defendant, as the alleged execution of the documents had no title or possession over the property, the learned circle officer, after considering the material documents and hearing, the parties rejected the petition of the defendants. The learned NRDC confirmed the order of the circle officer. On appeal, however, the additional collector Ranchi remanded the case back to the circle officer, hence the necessity of the suit. The defendant case, according to the written statement, in short is that the plaintiffs have got no cause of action for the suit. The suit is bad for misjoinder of several causes of action of various different dates and it is not maintainable. The claim of the plaintiff is barred by limitation and adverse position. The suit is also bad for defect of the parties. All the surviving sons or their successors in interest and daughters of Kamlakant are necessary parties and they have kept interdicted with a set purpose. Deception. The plaintiffs have got no title to the property and they are not in possession of the suit property at any time within 12 years of the filing of the suit. It is false to say that there was any family arrangement by which the suit property had been allotted to Kamlakant Bid. There was absolutely no reason and occasion for Sur Narayan Kushal Bid to choose Kamlakant alone over his 5 sons for the ownership of the property, and there was absolutely no reason and occasion for the other sons to approve such unreasonable choice and desire. There was no consideration for such a family arrangement. It is also false to say that there was any document drawn up in pursuance of the same. Such a document was never disclosed at any material point of time before and not even by Kamlakant before this CO. Therefore, these defendants believe that if any such document was brought into existence by the plaintiff, it is a forged and manufactured documents and cannot be accepted as genuine and valid. The further case of the defendant is that the Sur Narayan Bid was in possession of the suit land along with his 5 sons and their respective family. The family was very big. One, there was death of accommodation. After death of Sur Narayan Bid, Kamlakant Pir and his son left the parental residence and started living at Gurua. Plot number 2218 of Khata number 732 did not belong to Suraj Narayan Pir but belonged to his brother Deep Narayan, from whom Suraj Narayan had purchased the same. It is false to say that Kamlakant permitted his other brothers to live there. The other brothers used to reside thereby by virtue of their right and title. Their possession was not permissive. Gauri Prasad had sold his property containing a house measuring of decimal duly executed and registered deed of sale in the year 1962 for a sum of rupees 200 in plot number 2219. During the revisional survey plot number 2219 measuring 7 decimals contained only 2 house and 1 saran, Suraj Narayan had built several other houses in the same plot to accommodate his big family and even had purchased the house from his brother uh, Dutt Narayan plot 2218 Gauri Prasad after selling his property left the parental residence and went away to village Idar Hatu where he had settled with his family and children. The sale deed so executed in favor of the defendant is genuine, valid for consideration and they have been put in possession and even now they are in possession seizable. The further case of the defendant is that after Guhi's death, his two sons, Badan and Ajit, who were there till their father's death, had sold their property containing houses in 2 decimal to the defendants in the year 1967 for consideration of rupees 200,000 and execution the sale deed. They also went away to village Hidarhatu. Banwali did not go anywhere. His son Nagen is living in his own house. Nagen is not there. With the permission of Kamlakant, these defendants are in possession of their own rights, title, and by virtue of their aforesaid sale deed, it is not correct to say that plaintiffs came to know of the same in 1975 when the defendant applied for mutation. The plaintiffs have got no title to the property and the suit should be dismissed with cost. Therefore, issues have been framed.
These sale deeds were not challenged.
No challenge.
The prayer does not refer that it has been challenged.
No, well, it is not. It's not.
These sale deeds were not under challenge.
But one thing I am missing the after this, they preferred appeal, and thereafter appeal was demanded, and fresh issues were framed also regarding tenancy. Yes, this was the judgment one. There 4 issues have been framed. It was decreed. This judgment is of the year 1990. Thereafter, what has happened, my lord, perhaps it would be in the record, my lord. It was remanded back in the appeal. And 2 separate issues were confirmed, my lord. One judgment might be in the record, my lord, that is 21/12/1991 by the learned same trial court. My lord will know.
Trial court?
Yes. Because after remand, a specific issue was framed.
This is 8/1/1990.
90.
Thereafter?
The suit was decreed. They preferred appeal. In the appeal, limited remand was there. And by that remand, again suit was decreed, and that judgment is 21/12/1991.
I don't get it. Nor do I get that reference in any of the judgments. So where are you seeing this?
My lord, I am saying from the
So how does that make a difference? Even if it is there,
no,
confined to the question of law.
no, my lord, I only want to show, my lord, so that Subsequently, if it comes to the record that whether there was any demand or not, at the very outset, I am submitting.
I don't know. It is not there.
When I examined the record, it was in such a position that it started to destroy, so I left it. Anyway,
We go by the judgments, whatever they are.
Yes.
The appeal was allowed.
Yes.
What was the point for determination before that?
Now, my lord has seen the pleading, my lord has seen the issues.
Following points emerge for consideration.
Yes.
That is at para number 8. You read para number 8 of the application. पैरा 7 में तो लिखा हुआ है रिमांड होकर क्या
Yes.
It is mentioned.
Now, paragraph 8, my lord, some of the facts are admitted in the
You
suit.
read para 7 also.
Yes, the court below answered all the aforesaid issues in favor of the plaintiff and therefore decreed the suit of the plaintiff on contest with full cost. In course of hearing of this appeal, it transpires that the court below had not recorded on finding of some of the disputed facts between the parties. Therefore, the suit was remanded to the court below for the limited purpose to record finding on the issues framed by this court, which are as follows: whether the defendants are tenant in the suit premises and as alleged by the plaintiff or they are in possession of the suit premises on the basis of sentence executed by Bhari Prasad in the year 1962 and Bhadar Prasad and the Deep in the year 1967. This court below, after giving opportunity to the parties, has answered the aforesaid issues in favor of the plaintiff and has held that defendants are tenant in the suit premises. Thereafter, 8. Some of the facts are admitted in the suit. It is admitted case of the party that the suit property belongs to Surya Narayan Beed. It is further admitted case of the party that the Surya Narayan Beed and 5 sons had 5 sons, namely Gauri Prasad, Neem Ram, Banmali Beed, Kamla Khan and Anand Beed. It is not disputed that Anand Beed died issueless. It is further admitted that the plaintiffs are the sons of Kamla Khan Beed and grandsons of the original holder of the property, Surya Narayan Beed. In this appeal, the following points emerge for decision: whether the original owner of the suit property, Surya Narayan Beed, allotted the suit property to his Kamla Khan Beed by Exhibit 1 and whether Exhibit 1 confers right title and interest upon Kamla Khan Beed. And second, whether the defendants are tenants of Kamla Khan Beed in the premises described in Schedule B of the plan or whether the defendants are residing therein as rightful owner after purchasing the same from Gauri Prasad Beed in the year 1962 and from Ajit Chand Bhadar Chand Beed in the year 1967. Point number 1. The case of the plaintiff is that the suit property belonged to Surya Narayan Beed, who wanted to arrange the property during his lifetime in order to avoid dispute and the differences among his sons. The suit property was allotted to Kamla Prasad Beed in mutual family arrangement and a different document was drawn up by Surya Narayan Beed on 5/8/35, which was acknowledged by his all sons. It is further case of the plaintiff that Kamla Prasad Beed allowed some of his brothers to reside in the house standing on the suit premises and their possession was permissive. The further case of the plaintiff is that Gauri Prasad Beed and Govind Ram Beed left the suit premises and started to reside at Edanpattu. Banmali Beed, another son of Surya Narayan Beed, shifted to Tagatuli and after death of Banmali Beed, his son Lagan Chand Beed was permitted by Kamla Khan Beed to reside in a portion of suit property. Anand Beed, another son of Surya Narayan Beed, died bachelor. The defendants' appellants have admitted that the suit property was owned and possessed by Surya Narayan Beed, father of the Kamla Khan Prasad Beed, and grandfather of the plaintiff. They have disputed the alleged family arrangement made by Suryanarayan Peer. According to the appellant, all the sons of Suryanarayan Peer who were in possession of the suit premises separately as rightful owner, and Lagat with son of Banmali Vic is still residing in portion of suit premises as rightful owner. According to the defendants, Exhibit 1 is a false and fabricated document. Santosh Kumar Bid, PW1, is the son of Gauri Bid. Gauri Bid is admittedly the son of Suryanarayan Bid, the original owner of the suit property. He has stated in Para 2 of his evidence that his grandfather gave the suit land and the house standing thereon to his uncle Kamla Prasad Bid in family partition. In Para 9, he has stated that the suit property was given to Kamla Bid in the year 1934. He has stated that in the partition, Gauri Bid, the father of the witness, did not get any thing. He is unable to give any reason for not settlement anywhere to Gauri Prasad Bid. He has admitted in Para 10 of his evidence that Lagan Bid is still residing in part of the suit building. Lagan Bid is admittedly the grandson of Sundarai, being the son of Banwali Bid. Similar statement has been given Lakshmi Nahi in Para 8 of his statement. PW2 has stated that people say that Suryanarayan Bid had given the suit property to Kamla Kanti. The aforesaid statement shows that the knowledge of PW2 is based on the statement of others. He is not a witness to the creation of the alleged document. He had not talked with Suryanarayan Bid on this question. PW3 Madhusudan Bhagat has stated that the suit property was given to Kamla Kanti by his father. In Para 2 of his evidence, PW3 has given the description of the house as consisting of 3 rooms. According to him, one room is given in possession of Lagan Bid, another has fallen down, and the third one is in occupation of the defendant. PW5 is the plaintiff. He has stated that the suit property was given to his father by his grandfather in partition, and a document was created for the same. He has produced the document which has been marked as Exhibit 1 as a document is more than 30 years. In Para 14, PW5 has admitted that he did not pay rent for the suit land in the state of Bihar. He further admitted that he does not know whether his father had taken steps towards payment of rent for the suit land on the ground that the suit land exclusively belonged to him. In Para 10 of his evidence, the plaintiff PW5 has stated that his grandfather had executed a will in favor of his father in the year 1934, and his grandfather died 2 to 3 years after the execution of the document. He has admitted that he did not file any petition for the probate of the deed of will. From the oral evidence adduced on behalf of the plaintiff, it is clear that the plaintiff himself does not know about the nature of the alleged transaction made by Suryanarayan, original owner of the suit property, in favor of Kamla Khan, father of the plaintiff. In the plain, the document Exhibit 1 has been termed as a family arrangement. In the evidence, it has come that the suit land was given to Kamla Khan in family partition. The plaintiff says in course of cross examination that a deed of will was executed by Suryanarayan Bid in favor of Kamla Khan. It is further clear that Lagan Bid, son of Banmali Bid, is residing in a portion of the suit premises. The plaintiffs have deposed that Banmali Bid is residing in the suit premises with the permission of the Kamla Khan. Lagan Bid has not been examined by the plaintiff as witness, although the plaintiff have got no enmity with him. Plaintiff has admitted in Para 9 of his evidence that he has no dispute of any kind with Lagan Bid. The evidence of Lagan Bid supporting the claim of the plaintiff could have been much of such importance as he belongs to one branch of Suryanarayan Bid. Exhibit 1 is a document on which the plaintiff bases his entire case. Even if the Exhibit 1 is taken as a genuine one, its plain reading does not suggest it either a document of family partition or a document of will. The relevant portion of the document read as follows: हम अपने जिंदगी में हमारे मकान हैं इसका
आराम से बोलो धीरे धीरे
हम अपने जिंदगी में हमारे मकान में सहन जिसका खाता नंबर प्लॉट नंबर नीचे लिखा जाता है। So पूर्ण जायदाद को आज के तारीख से लिख के जिम्मा दिया, वो वाजिब दखलकार दाखिल किया चाहिए कि हमारा लड़का कमलाकांत भी इस जायदाद में दखलकार होकर रहेगा एवं अपना दुकान देने या एक दूसरे को किराया में
नहीं, इस जायदाद में दखलकार होकर
वो रहकर, वो है दिखने में जो लग रहा है लेकिन है वो रहकर
अपना दुकान
देने
देने
वो कितने सॉरी या एक दूसरे को किराया में देने अपने मुनासिब समझ कर
फिर किया
वो हमारी जिंदगी भर पालन पोषण सेवा टहल देख रेख यानी अंत तक कि हमारा भार इसी के ऊपर रह गया, वो कर नाम ये नेक्स्ट डे आई डू नॉट रीड नाम देगा
चौकीदारी टैक्स
नहीं वो रह गया वो अच्छा शान चौकीदारी तो आगे है रह गया इसी के ऊपर रह गया वो कर नाम देगा नहीं नाम देगा वो साल चौकीदारी टैक्स देवे अपने नाम से रसीद लेते जाए, इसे हम हमारे वारिसान कायम मुकीमयान या चारों लड़कों को शेष जायदाद पर किसी का हक और अधिकार नहीं रहा, वो आइंदा पर होगा। अब आज के तारीख
वो न आइंदा होगा।
हाँ, वो ना आइंदा होगा, आइंदा पर होगा।
आज से ये हमारे लड़का कमल विद का हुआ ये फैमिली पार्टीशन
नहीं
है ना आगे बढ़िए
ना कायदी सी
it is out and out transferring the property
out and out family arrangement in which a father gives his property to his son.
family arrangement
Yes.
family arrangement में कौन है
बेटा जो ओनर है वो अपना प्रॉपर्टी को अपने लाइफ टाइम में एक बेटा को देगा।
फैमिली अरेंजमेंट में किसको बोलते हैं व्हेन एवरीबॉडी इज देयर एंड दे एग्री कि ठीक है ये प्रॉपर्टी इस बेटा को जाएगा बट ड्यूरिंग द लाइफ टाइम ऑफ फादर इफ ही सेज दैट दिस प्रॉपर्टी विल गो टू हिम एंड अदर्स आर नॉट अ पार्टी टू इट इट्स अ यूनिलैटरल एक्ट ऑफ द फादर giving the property to one of his son.
Yes, my
so
lord
how
is,
can it be treated as a family arrangement?
Yes, my lord is correct. That it is a unilateral action of a father giving a property to his son.
To his son,
Yes.
right?
It can be accepted.
I don't know whether it can
No,
be
no, my
accepted or
lord,
not
we-
accepted.
my lord, it is inferred.
No, this is what I can derive out of this.
Yes. So the
nature of the transaction is a gift.
Nature of the
Practically
transaction is
it's
a
a
gift only.
where
Because
be
there is no
over-
consideration involved.
now yes.
There is no consideration. Had there been any consideration, then the situation is different. Here the only, there is no consideration as such involved. He is giving the property to his son. Therefore it's a gift. Now you read it, read
Now,
further.
now for gift, my lord, what are the requirements of gift?
No, we'll come to that later.
Yes.
There are
15.
15 discussed.
The nature of document is of a gift, because by these documents Surya Narayan Pit transfers his all right, title and interest in the Su property and delivers possession of the same to Kamalakant Pit. the document of gift requires to be compulsorily registered and attested by two witnesses. The document is neither registered nor attested by two witnesses. So the document does not effect as a gift.
A gift के लिए
Yes, that's
two
why I-
witnesses का attestation
Yes,
जरूरी है?
yes. So that's why I told that this could not be a gift.
Okay. So
No.
this document
It's
did
not a
not
gift.
take effect as a gift
Yeah.
because it is not
This
registered.
document cannot be a gift. This is the finding of the,
This document is nothing.
but a kind of a document which was executed by,
This particular document cannot be relied upon. And in
but I am
evidence.
questioning to myself, a document of the year 1934, which has not been disputed by or denied by the other legal heirs. Can it be disbelieved from the material, not from assumption? Beyond materials, not. Beyond from the materials of this suit, if the plaintiff or the any other legal heir, any other. Now
Even if,
suppose I say,
even if there is a transfer of some property, maybe by gift or whatever, which is unregistered
question
and
comes-
undisputed by any of the parties,
yes, now,
then
now
it can be
my
taken
lord is
into
correct.
evidence.
Yes, my lord is correct. So now this is unregistered document. My lord is correct that this is an so now this question. So my lord, so next finding will be demolished by my lord's observation. Kindly see.
आगे पढ़िए.
It is not a case of the plaintiff that his grandfather executed a deed of gift in favor of his dear father. So this finding is given by the learned first appellate court, taking it that it is a gift. Although side by side, taking a finding that elements of gift are not present in exhibit 1.
आगे पढ़िए.
No.
The exhibit
And
1.
this is important, my lord. That's why I'm sorry to say, my lord, I'm again emphasizing that. The exhibit 1 falsify the statement of plaintiff PW5 that his grandfather executed a will in favor of his father. The document cannot be considered as a deed of partition. A deed of partition. In fact, Surya Narayan Pit, as the absolute owner of this property, was, this is also important, was entitled to dispose of his property by way of gift or sale. Thereafter, he could not have partitioned his absolute property amongst his sons to take effect during his lifetime or after his death. So this finding is erroneous. The document exhibit 1 does not describe the share of the other sons of Surya. There was no necessity. The defendant has taken the plea. Why I am saying, sometimes it is necessary to place my point regarding that finding. The court below that it does not describe the share of other sons. If other son does not dispute, if some property has given by my father to my brother, if I do not dispute it, then there is no question of any finding by any court of law.
All of them were party.
Others are party.
All of them.
All of them, but others, the persons on the basis.
All the brothers and their legal heirs are party.
All the legal heirs, not a party.
Then
Because my lord has gone through the contents of plaint, that what necessitated to filing this suit. The necessity to filing this suit, that when the plaintiff got knowledge that the purchaser have gone for mutation of the lands on the basis of two sale deeds executed by Govardhan Bill. So Govardhan Bill was necessary party and he has been made as a party. Govardhan Bill was died. So their sons have been arraigned as a defendant. Now thereafter, the defendant has taken the plea that exhibit 1 is a forged and fabricated document. The exhibit 1 is of the year 1934 neither Kamla Prasad Bid nor the plaintiff taken any step for mutation of the suit land and for the payment of rent to the state of Bihar, claiming the suit property as his exclusive one. The silence of the plaintiff or their father for more than 50 years goes to create doubt about the genuineness of the document. Exhibit 1. It is against the conduct of human being that he will not take steps necessary regarding his property. On the basis of above discussion, I find and hold that Exhibit 1 does not confer any right, title, interest upon the plaintiff. It did not confer any right, title, interest upon Kamla Kalbi. The document Exhibit 1 appears to be doubtful and cannot be relied. The finding of this connect to the court below on this point is reversed. So now, my lord, in finding para 16, so my lord, so far as earlier finding, my lord, I have submitted my submission. So as finding in para 16 that the defendant has taken plea that Exhibit 1 is a forged and fabricated document. But now a party coming in the court of law taking an assertion of fraud. Now elements of frauds have been pleaded, but whether it has been proved, it has not, no evidence has been laid by the necessary party purchaser to
We are
prove.
not on that.
I
substantial
am
question of
on
law.
Exhibit 1.
We are on Exhibit 1.
Yes.
A substantial question of law number A and B.
Yes.
There is no whisper of any fraud in this.
No, I'm not saying.
You just tell us.
Yes.
You just refer to exhibit this substantial question of law
So,
number A
yes,
and B.
A and B. So now A and B, my lord, court learned first appellate court has given a finding.
Let us see the finding of the trial court on this. What
Yes.
finding the trial court
My
has given.
Issue number 4, my lord, finding internal
At
gain.
internal page 12.
Yes, yes, page 12. Exhibit 1, earlier evidences has been discussed and thereafter it has been from second. Exhibit 1 is not a partition deed, it is only a memorandum of partition. A kind of agreement has been noted to avoid future differences. Noted to avoid future differences.
So this is the evidence of PW1.
Right.
You just come to the bottom. One who is conversant with the writing of the man is proved by that man. Exhibit 1 was filed much before filing of the suit.
I could not understand what my lord varies.
At page number 12, bottom.
Yes, one who is conversant with the writing of the man is proved by that man. Exhibit 1 was filed much before filing of the suit, but that does not controvert that this signature of this does not tally with the signature of the sale deed. Exhibit A, B. Gohin Prasad Bait has made his signature on Exhibit 1, the family arrangement, and his son PW1 Santosh Kumar Bid has also supported the fact of execution and acceptance of the aforesaid deed by his father. The plaintiff's witness have proved, so my lord, this was the Exhibit 1 finding. So the learned trial court has taken note of the fact that with the admitted document of Exhibit A and D, it has not been, the execution of Exhibit 1 has not been controverted. Gohin Prasad Bid has made his signature on Exhibit 1. The family arrangement, and his son P.W. Santosh Kumar Bid has has supported the said fact of exclusion and acceptance
In
of
the previous paragraph, they say that all the 5 brothers have made their signature on the deed from perusal of Exhibit 1 and Exhibit A and B. It appears that the signature of Gauri Prasad will tally on all the exhibits. Therefore, it cannot be said that Exhibit 1 is a manufactured document. Thus, Exhibit 1 is a genuine document and acted upon. The family of the plaintiffs are governed by Dayabhaga School of Hindu Law, according to which father is competent to give his property even to one of his son. In this case also, Surendranayan Bid gave the suit land to Kamlakant Bid, the father of the plaintiffs, and another land to other brothers in different villages, as it appears from the evidence. It is not appearing from the exhibit. And this particular exhibit, even if it is taken as a family arrangement, it is otherwise creating a right. Otherwise creating a right. It is not a memorandum, not at all. It is not a memorandum. By this particular document only,
yes.
the right is being created.
Yes, and there is a finding that this property by virtue of this unregistered right has been created and given to Kamlakant Bid, but there is finding on the basis of evidence that other property of Surendranayan Bid was given to the other son. What it means? That a person, my lord, kindly grant. My lord, it means that a person who had right by birth in the paternal property was given some right.
They are governed by Dayabhaga School of Law.
तो उसमें सन को राइट तो होता ही है.
क्या होता है?
सन को तो राइट होता है, डाउटर्स को भी राइट.
You see, the property belongs to the father, and then only the question of after his father it devolves upon the son. Father has the exclusive right to
Yes.
dispose of the property.
Yes.
Right? Sons are don't have any right.
Yes.
Yes.
अगर so my lord, so sons could have any right over the father of property of the father after his death.
Yes.
Correct. Now my lord, during his lifetime, a father makes some certain kind of family arrangement in which Exhibit 1 was one of the document and other property has been given to the others.
No, it is not reflecting from exhibit.
My lord, from the fact, my lord has just gone. My lord has just found
Yes,
it.
it is not reflecting from exhibit 1. There may be some other arrangement, there may be some other
There
transactions.
may not be, my lord. There is a finding of the trial court that the other property has been given to the other son, which finding has not been reversed.
We are not bothered about that. We will read only exhibit 1.
Which one? Yes.
Exhibit 1, you see, under normal circumstances, if there is a family arrangement and if it is not a recital of the family arrangement taken earlier,
Yes.
a memorandum.
We cannot do. My lord, it's not law.
So,
My lord,
by
how
on
can
the
I
face
differ?
of this document, that is creating a right upon the son.
Yes.
So, the appellate court has rightly held that it was compulsorily registrable.
Yes.
Yes.
Now, the learned appellate court has given a finding that it requires registration. But what would be the impact if this document takes effect after death of father? We must know, my lord. We must know because Exhibit 1, because there is a evidence, my lord, I understand, my lord, that this document is unregistered. I understand. My lord, I understand, my lord, that by virtue of this document, the learned trial court has said that this is not a family arrangement and rather this is a kind of gift deed. But subsequently, my lord, the first appellate court has himself held that this is not a gift because the mandatory requirement of a testing witness is not there. Now, therefore, my lord, the substantial question should be decided in my favor, my lord, because the learned trial court cannot hold it is a gift. And taking it is that this cannot be a gift.
This is what you have to say so far as substantial question of law number A and B are concerned. Right?
More is required, because I so far as, my lord, kindly we see the substantial question of law, whether the learned court of appeal below or in law, point number B, in holding that Exhibit 1 was a deed of gift rather than memorandum of family arrangement. Now, my lord, my submission that the learned trial court has first held, learned first appellate court has first held that Exhibit 1 is a deed of gift. The opening line, my lord, has gone through, my lord, it is a deed of gift. Thereafter, the learned first appellate court himself says, my lord, that it is not a deed of gift because there is lack of two attesting witnesses.
Under which provision of law two attesting witnesses required for gift?
Attestation, my lord, section 3 of Transfer of Property Act.
You see, you just tell us for the purposes of transfer of property, whatever be the mode and manner of transfer of property by sale, the same is the mode and manner of transfer of property by gift. Except that for gift there will be no consideration. Correct? So there is no difference between them.
Yes, I am not differing, my lord. So far
What
as
attesting witness
so far as my lord-
somebody is talking about?
yes,
Whenever there is a register, attesting witnesses question comes only when there is a will, right? Because will on Sada page is also valid in
yes,
the eyes of
yes,
law.
yes.
But so far as gift is concerned or sale is concerned, if a document by itself is transferring the property, not admissible in evidence.
That is law. How can I give a mirror? I am not. So I could not be so mirror. Could not. But my submission was mirror. That's why mirror I was taking mirror. Kindly allow me two things, mirror. Kindly see the plate. Kindly allow me, my lord, some time, my lord. See, my lord, this is a very relevant question that whether Exhibit 1 could be disbelieved by the learned first appellate court while misinterpreting it, that others, in view of the fact that the others legal heirs of the suit narrative has not disputed. Kindly take, my lord, the blame. Kindly take.
Even if there is an unregistered document and nobody disputes it, it is absolutely inadmissible in evidence. It has got no value. It is a scrap of paper. Throw it into the dustbin.
My lord, is saying, my lord, kindly see section 49. I understand. I cannot claim. I understand, my lord, that
Nothing can be claimed out of this document. Neither family arrangement nor partition, and then it is not a memorandum of family arrangement at all. It is not a memorandum by any stretch of imagination. It is not a memorandum. Memorandum means something
means
which has
earlier
already
one, my
happened.
lord, is correct.
It
Yes,
is not
yes.
a memorandum of family
Yes,
arrangement.
yes. That is true. That is true.
अब
Now,
आगे क्या करना हो गया
नहीं हुआ नहीं इतना जल्दी अगर
हो गया
नहीं अगर इतना जल्दी कम से कम अपना बेस्ट एफर्ट तो
नहीं,
लगाए
अपना बेस्ट एफर्ट लगाइए लेकिन रिपीट मत करिए आपकी बात हम समझ गए रिपीट मत करिए अपना बेस्ट एफर्ट आपको जितना लगाना है
now so far as my lord inadmissibility of unregistered document that it is a waste paper kindly take a minute section 49 proviso of original registration act
और collateral
yes
what is that collateral purpose
collateral purposes means the property was given by father to his son and son was in possession is a collateral fact collateral purposes so if my I will have no case lord if my lord is say I will not argue thereafter I will not argue
I will not say anything.
so my lord One thing is just that whether in Daya Bhaga, I am not aware whether in Daya Bhaga this document could be created or not. Because in a Mitakshara, why not is correct that by birth having right, so no new right is created. So, my argument may be noted, my lord. Only 1 or 2 days time may be given. No, मतलब पार्ट हट
ये part
तब तो अगर हम प्लेट नहीं दिखाएंगे WS
हम तो पढ़ ही रहे हैं, आप जो पढ़ेंगे सब पढ़ेंगे, लेकिन टाइम
थोड़ा नहीं टाइम केवल कल के लिए कर इसको आज को हो तो एग्जाम
टाइम का काम नहीं।
वो जो 93 का सेकंड अपील इतना दिन माइलॉट के कारण केवल डिसाइड
93 का सेकंड अपील, आप 93 में प्रैक्टिस
माइलॉट
ज्वाइन किए
डिसाइड
थे?
नहीं, हम तो मेरा बात ऐसी
नहीं किए थे ना, तो ये सेकंड अपील मैच्योर होकर आपकी मैच्योरिटी तक पहुंच गया इसलिए इसमें कोई
माइलॉट
हाँ रिस्पोंडेंट बताइए, बाकी सब सब्सटेंशियल क्वेश्चन ऑफ लॉ में कुछ बोलना है?
नहीं मुझे बोलना है माइलॉट नहीं आई मस्ट
जो बोलना है आप बोल दीजिए ना,
I must
कंप्लीट
not I must raise all the now माइलॉट kindly
थर्ड में
now one more argument regarding exhibit 1 माइलॉट one more required argument that in absence of controverting or disputing by any party by leading evidence, exhibit 1 could not be disbelieved by the learned first attempt. Particularly in view of the fact particularly which is the substantial question of substantial question of law question number E. Particularly in view of the evidence of Santosh Kumar Peth, this kindly grant me some time, referring the evidence of those evidences which could prove whether there was any kind of family arrangement in relation to exhibit 1 or not. Kindly take PW1, evidence of PW1. PW1 is Santosh Kumar Bid and he is son of Gauri Prasad Bid.
in whose favor exhibit 1 was exhibited?
Yeah, by whom the purchaser claimed that they have purchased it.
Gauri Prasad
Bid.
and exhibit 1 was in favor of
Kamla Kant Bid.
Kamla. So PW1 is the vendor, son of the vendor.
Son of the vendor of the contesting defendant purchaser.
Did he file written statement? He was a party?
Gauri Prasad.
No, this Santosh Kumar Bid. Was he a party?
No.
He's not a party. His father is
His
also not
father
a
was
party.
a party. Govardhan Bid. ये दूसरा है son of Durga Chandra. Govardhan दूसरा. He was not.
ना vendor party है.
उनका तो डेथ हो गई.
उनका डेथ हो गया।
हाँ।
उनको
बाकी
तो
सब
बाद
लोग
में-
हैं, गोवर्धन विद है, हरिनारायण विद की वाइफ है, उनके बच्चे हैं, फिर विभूति भूषण विद है। So while I am referring to the evidence of PW1, Santosh Kumar Vidd. पैराग्राफ 2, सूर्य नारायण विद मेरे दादा थे, मेरे दादा सूर्य नारायण विद पारस्परिक बंटवारा अपने लड़कों के बीच में किए, जिसमें वाद भूमि वाली जमीन को कमलाकांत विद को मिला। इस बात को सभी भाई लोग स्वीकार किए। उसमें कमलाकांत विद भाड़ा में गोवर्धन विद को दिए। गौरी वो ही विद गुंडू से इधर हाथू बोझा गए, वो वही रहने लगे। बनमाली विद टांगा टोला जाकर रहने लगे। अन्य भाइयों को कमला विद के संपत्ति से कोई सरोकार नहीं था। मेरे पिताजी गोवर्धन विद को कोई जमीन जायदाद बिक्री नहीं किए हैं। विवादी जमीन में गोवर्धन प्रतिवादी का हक हिस्सा दखल कब्जा नहीं है, वह केवल एक कोठरी में किराएदार है।
Govardhan Bid is the tenant.
Defendant number 1 who was claims to be tenant and who is purchased from.
So what do you want to say on this? सब क्या डिराइव करते हैं
इससे ये डिराइव करते हैं कि मतलब जो सेल डीड है, by virtue of which it has been pleaded that Govardhan Bid has sold the property. So
Gauri Prasad Bid.
Gauri Prasad Bid has sold the property. So he has not sold the property, my lord.
He had sold the property by virtue of registered deed.
Yes. So now the case of the plaintiff was that the Gauri Prasad Bid has not executed any sale deed. It is a forged document.
No declaration has been sought.
No declaration has been sought. No
They have
declaration.
not sought any declaration to declare that the sale deed is forged.
Yes.
Beyond the case. The submission is beyond the.
No. That is the pleading.
But no relief.
No relief. I accept. So far, this was the evidence of the PW1 for which substantial question. Now, my lord, a small request, my lord. So, there is a finding of the learned trial court that it bears the signature of some of the son of the original owner. Finding of the first appellate court is there is no signature. So now the best my lord could see exhibit 1 and whether signature of other person is there or only Surkant Mir is there.
There is a finding of the appellate court that there is no signature of any other
There
person.
is a finding.
छूने में हमको डर लगता है।
My lord, paragraph 16 is just above line 1. तो डर गए, छुए नहीं मैं, my lord. But it appears that there are some signatures. I have flagged it, my lord, that document.
पांच सिग्नेचर तो
है नहीं, 5 नहीं है। इनका जो कहना है ट्रायल कोर्ट का जो फाइंडिंग है कि does not yeah. There are some signatures.
कहाँ है एपिलेट कोर्ट का फाइंडिंग?
नहीं उस पे सिग्नेचर पे नहीं, ट्रायल कोर्ट का फाइंडिंग है कि सबका सिग्नेचर है।
Incorrect.
Yes.
That finding is not correct.
Incorrect. मालूम नहीं बात।
आपको क्या बोलना है रिस्पोंडेंट? यस, क्या हुआ? बुलाइए, तब तक हम इनका कहानी लिखते हैं। ये सब केस को आप लोग बहस कर ले रहे हैं, हमको लगता है यही बहुत बड़ी बात है। बिकॉज DAD करके क्या हो?
नहीं।
जो भी है
यस
ना,
कुछ नहीं है तो कहाँ से लाएंगे?
पहले अलग ही तरीके से सब्सटेंशियल क्वेश्चन ऑफ लॉ वगैरह फ्रेम होता था, लेकिन आज के दिन में इस तरह से तो बनेगा ही नहीं substantial question. And with the passage of time, lot many judgments have come, much water has flown. So law has changed
Beyond
substantially.
my not record my not now entire case of the plaintiff is that they are the strangers and now law has already been changed to property, joint property can be sold. There is no illegality.
Essay number 94 of 1993. Heard the learned counsels for the parties. This appeal has been filed against the judgment dated 30/9/1993, within bracket decree signed on 11/10/1993, passed by learned 6th Additional Judicial Commissioner Ranchi, whereby title appeal number 13 of 1990 slash title appeal number 6 of 1991 has been allowed, and the judgment dated 8/1/1990, within bracket decree signed on 5/2/1990, passed by learned Subjudge Roman 3 Kuti in title suit number 302 of 1985 has been allowed. The suit was decreed on contest. The appellate court has set aside the trial court judgment, and consequently the plaintiff is the appellant before this court. This appeal was admitted for final hearing by order dated 1/10/1994 on the following substantial questions of law. The suit was filed for a declaration of title over Schedule A and B property, and for recovery of possession of Schedule B property after evicting the defendants from the suit property. the case of the plaintiff was that block number 2218 under Khata number 732 area 0.1 decimal and plot number 2219 under Khata number 732 area 0.07 decimal were owned and possessed by Suraj Narayan Bid, the grandfather of the plaintiff, who died leaving behind 5 sons, namely Gauri Prasad Bid, Gugu Ram Bid, Banmali Bid, Kamlakant Bid, and Anand Prasad Bid. Gauri Prasad Bid died leaving behind his one son, namely Santosh Kumar Bid, and 3 daughters. Guru Ram Bid also died leaving behind 3 sons, Badal Chand, Ajit Chand, and Ratu Chand, and also his widow Uma Devi. Banwali Bid died leaving behind the plaintiffs, being his sons, 2 daughters, and widow. The daughters and widow have not of Banwali Bid have not been included in the suit. Anand Prasad Bid died bachelor. It was the further case of the plaintiff that Suraj Narayan Bid during his lifetime wanted to arrange his properties in such a manner that after his death there might not be any dispute amongst his sons. Accordingly, the suit property in a mutual family arrangement was allotted to Kamlakant Bid, and a document was drawn up by Suraj Narayan Bid and all his 5 sons, by which the allotment of suit property to Kamlakant Bid was acknowledged and confirmed on 5/8/1934. Thereafter, Kamlakant Bid was in possession of the suit property. However, he permitted his brothers to reside in the house over the suit property, and it was the case of the plaintiff that the possession of the said brothers was permissive possession. The further case of the plaintiff was that Gauri Prasad Bid and Gubi Ram Bid had left the suit property, and Banwali Bid had also shifted to another place. And after death of Banmali Bid, his son was permitted by Kamlakant Bid to reside in a portion of the suit property. The further case of the plaintiff was that the defendant was inducted as a tenant by Kamlakant Bid in respect to another portion of suit property. However, in the year 1975, Kamlakant Bid came to know that the defendant, who were tenants, had applied for mutation of the property in their name with respect to 4 decimal in connection with plot number 2219 and the Khata number 732. Immediately thereafter, he objected, and for the first time, Kamlakant Bid came to know that the defendants were trying to set up title over the property on the basis of 2 sale deeds alleged to have been executed by Gauri Prasad Bid in the year 1962 and by Ajit Chand Bid and Badal Chand Bid in the year 1967. It was alleged that the said sale deeds were forged and fabricated documents and were not executed by the persons alleged, and it was also alleged that the said sale deeds were without any consideration. It was their further case that the circle officer rejected the petition of mutation filed by the defendants. The land reform deputy collector confirmed the order of the circle officer. However, the additional collector Ranchi remanded the case back to the circle officer, and ultimately the suit was filed. On the other hand, the case of the defendants was that the suit was not maintainable, it was barred by limitation and they claimed adverse possession. It was also asserted that all the surviving sons or their successors in interest and the daughters of Kamla Kant bid when necessary party it was asserted that the plaintiffs had no title over the property and they were not in possession of the suit property for more than last 12 years. The defendants stated that it was false to say that there was family arrangement by which the suit property was allocated to Kamla Khan Bid, and there was no reason as to why Surya Narayan Bid would choose Kamla Khan over his 5 sons. It was also asserted that there was no consideration to the family arrangement. It was asserted by the defendants that the document of family arrangement was forged and fabricated, and it cannot be accepted as valid. It was the further case of the defendant that after death of Suraj Narayan Bid, Kamla Khan Bid and his sons left the parental residence and started living at Durga Mode. Plot number 2218 of Khata number 732 did not belong to Suraj Narayan Bid, but it belonged to his brother Deep Narayan, from whom Suraj Narayan had purchased the same. It was denied that Kamla Khan permitted other brothers to live over the property. Rather, they were residing over the property by their own right and title. It was denied that their possession was permissive. It was also asserted by the defendants that Gauri Prasad had sold his property containing a house measuring of decimal portion of the suit property बेचे थे ना? Yes, portion of the suit property बेचे थे ना?
Yes.
Sold a portion of the suit property in the year 1962 by registered deed in plot number 2219, which was measuring 7 decimal, containing 2 houses and 1 sign. Suraj Narayan had built several houses in the same plot to accommodate his big family, and even had purchased from his brother plot number 2218. It was further asserted that Gauri Prasad, after selling his property, left the parental residence and went away to his village. The sale deed executed in favor of defendant was genuine, valid, and for consideration, and they were put in possession of the property. It was the further case that after Guh, death, his two sons, Badal and Ajit, who were there till their father's death, sold their property containing 2 decimil to the defendants in the year 1967 for consideration of rupees 2,000 and executed the sale deed. And they also went to their village. It was also asserted that Nagin was living in his own house, and it was not that he was living with the permission of Kamlakant. The defendants claimed that they were in possession of the property by their own right title and by virtue of their foresaid sale deeds. It was also asserted that it was not correct to say that the plaintiffs came to know about the sale deeds only in the year 1975 when the defendants applied for mutation. It was stated that the plaintiffs had no right, title and interest over this property. The following issues were framed by the learned trial court. So far as issue number 4 is concerned, the learned trial court एक सेकंड the learned trial court was of the view that the defendants claimed to have purchased the suit land in 1962 and 1967 but remained silent till 1974. After passing of 12 years and 13 years, they filed a mutation petition in 1975 for the reasons best known to them. It was observed that the general convention is that after purchase of any land, the people immediately file mutation petition, and since there was no explanation for 12 and 13 years delay in filing the mutation petition, it created doubt about the genuineness of the alleged sale deed. The learned court also considered the evidence of the defendant According to them, all the 4 brothers got 2 decimal each. The court observed that the exhibit B showed that Gauri Prasad did mortgage 3 decimal of land to Tuxel, which was not convincing, which is not convincing. Sale deed exhibit A was executed for 2 decimal only, and there was no explanation for 1 decimal area. It was observed that Gauri Prasad got 2 decimal share, then why did he sell 3 decimal? It was further observed that the boundary also differed in both the exhibits A and B. The learned court also observed that the son of the vendor, Gauri Prasad Vitt, namely Santosh Kumar Vitt, denied this execution of the sale deed by his father. And ultimately the court held that both the sale deeds were forgery and the executant had no right, title and interest and possession to execute the sale deed. and held that the plaintiffs have got valid right title over the suit property. The issue number 4 was decided in favor of the plaintiff and against the defendant. So far as issue number 1, 2, 3 and 5 are concerned, the learned trial court observed that held that the possession of the defendants were permissive possession. The point of limitation is a mixed question of fact and law, and there must be a point from which the limitation starts. The court observed that the defendants have not been able to give specification with regard to their claim of adverse possession, and ultimately held that the suit was not barred by limitation and adverse possession. The suit was maintainable, and the plaintiff had the valid cause of action. And issue number 1, 2, 3 and 5 were decided in favor of the plaintiffs and against the defendants, and the suit was ultimately defeated. क्या बोलना है? कहाँ चले गए सर? फिर चले गए? चलिए. So far as the just a moment, ऐसा piecemeal नहीं चलता. Second appeal इस तरह से नहीं चलता है. इधर गए, उधर गए, कूदते फांदते second appeal नहीं होता. ठीक है? And your senior knows about it. So far as the first appellate court is concerned, the court formulated the following points for determination. Para number 6. नहीं, para 6. It appears from the appellate court's judgment that the trial court judgment was challenged, and during the pendency of the appeal before the first appellate court, certain issue was framed and finding was to be recorded by the learned trial court. The issue framed was whether the defendants are tenants in the suit premises as alleged by the plaintiffs, or they are in possession of the suit premises on the basis of sale deeds executed by Gauri Prasad in the year 1962 and Badal and Ajit in the year 1967. The said issue was ultimately decided by the learned trial court, and the trial court ultimately held that the defendants were tenants in the suit property. The appellate court thereafter recorded the admitted facts in paragraph 8 that the suit property belonged to Suryanarayan Bid. He had 5 sons, namely Gauri Prasad, Him Ram, Banwali Bid, Kamal Kant Bid and Anand Bid. Semicolon, Anand Bid had died issueless, and the plaintiffs were the sons of Kamla Kant Bid and grandsons of the original holder of the property, Suryanarayan Bid. The learned first appellate court thereafter framed the following points for determination in paragraph 8 itself. The learned first appellate court decided the first point of determination and also quoted the contents of Exhibit 1 and held that the Exhibit 1 is in the nature of gift because by this document Surya Narayan Bid transferred all his right, title and interest in the suit property and delivered possession of the same to Kamlakant Bid. The court was of the view that the document of gift was required to be compulsorily registered and was also required to have attestation of two witnesses, which was not done. The court was of the view that this document could not have taken effect as a gift. The court also observed that it was not the case of the plaintiff that his grandfather had executed a deed of gift in favor of their father. The plaintiff PW5 had stated that grandfather had executed a will in favor of his father. The court also observed that the document cannot be considered as a deed of partition. It was observed that Surya Narayan Bid was the absolute owner of the suit property and was entitled to dispose of this property by way of will, gift or sale. However, he could not have partitioned his absolute property amongst his son to take effect during his lifetime after death. The learned court also observed that the Exhibit 1 was not acted upon inasmuch as no steps were taken by the plaintiffs or their father for more than 50 years. Ultimately, the learned first appellate court held that the Exhibit 1 did not confer any right, title and interest upon the plaintiffs. It did not confer title and interest upon Kamlakant Bid, and Exhibit 1 appeared to be doubtful and cannot be relied upon. The finding of the learned trial court on this point was reversed. So far as the point number 2 is concerned, the learned first appellate court recorded a finding that the defendants were occupying a portion of the suit premises from 1962. And Exhibit A showed that they had purchased 2 decimal of land from Gauri Prasad Bid, one of the sons of Surya Narayan Bid in 1962. The defendant further purchased 2 decimal of land in dispute from Ajit and Badal, sons of Puri Ram Bid. Exhibit C showed that Puri Ram Bid was also allotted 1/3 share in the suit property. The learned court held that there was no evidence to show that the defendants were residing in the suit property as tenant. There was no proof that the defendants had ever paid rent for the property described in Schedule B, either to Kamlakant Bid or to his sons who were plaintiffs in the suit. The learned court ultimately held that the defendants were residing in the suit property not as a tenant of the plaintiffs but as the owners of the portion occupied by them. The finding of the learned trial court on this point was also reversed. The learned court also observed that the plaintiffs had not made the other legal years of Suryanarayan Vid as party in the suit. And the plaintiffs were not entitled for a declaration of title over the suit property in Schedule A of the plaint, especially when one portion of the property described in Schedule A was in possession of Lagan Vid, son of Guliram Vid. This court finds that the finding of the learned appellate court that the defendants were not occupying the suit property at Schedule B as tenant has attained finality inasmuch as there is no substantial question of law framed relating to the tenancy of the defendant. हाँ मिस्टर आप बताइए इनका सबमिशन नोट कर लेते हैं फिर आप The learned counsel for the appellant, while referring to the Exhibit 1, has submitted that the findings of the court reveal that there were other properties and they were also allocated to different brothers. He has also submitted that there was no legal impediment in allocation of the suit property exclusively to Kamla Khan Bid. He has further submitted that the first appellate court has given conflicting finding inasmuch as on the one hand it has been held that the Exhibit 1 appears to be a gift deed, and on the other hand it has been held that in absence of attestation and registration it cannot be said to be a gift deed. The learned counsel has submitted that the Exhibit 1 has been wrongly interpreted by the learned first appellate court, and the said document is a memorandum of family arrangement, and therefore the first and second substantial question of law are fit to be answered in favor of the appellant and against the respondents. He has also submitted that the direct consequence of such a finding would be that the right title interest of the plaintiff would be declared with respect to the suit property by virtue of Exhibit 1. जहाँ लिखे ना टेनेंट वाला फाइनल हो गया जो मत लिखिए एक ही लाइन लिखिए. The learned counsel, while referring to the third substantial question of law, has submitted that the defendants were not residing over the suit property as owners, but they were tenants over the suit property. The learned counsel, while referring to the fourth substantial question of law, has submitted that the learned court had submitted that regarding the jointness of the property, the defendants who are the strangers to the family could not have acquired title over a specified portion of the joint property. The learned counsel, while referring to substantial question of law number E, the learned counsel has referred to the evidence of Santosh Kumar Bid, who was examined as Santosh Kumar Bid, son of Gauri Prasad Bid, the vendor the son of Gauri Prasad Bid, and has submitted that he has clearly stated that Kamla Kant Bid had got the suit property from his father Suraj Narayan Bid in the year 1934 by a written document. And the allocation of property to exclusively to Kamla Kant Bid was accepted by all the brothers. He has also denied that his father had sold the property to the defendant. यही तीन चीज़ है ना इसमें? The learned counsel submits that the vendor of the property, the son of the vendor of the property, has himself deposed that his father had not sold the property, and the evidence of PW1 has not been properly examined by the learned first appellate court while reversing the judgment and decree of the learned trial court. हाँ, आपको क्या बोलना है?
नहीं करना है जो the exhibit 1 is the paramount title, basic title not of the plaintiff. Now what is the nature of the document that has not been discussed by the learned trial court at all? On the other hand, your lordship may kindly see page 16 of the trial court judgment. It relates to issue number 4. Issue number 4 relates to the declaration of right title interest. Then Lord, after is considering the evidence on record, ultimately para 16, page 16 of the trial court, because it is not para wise, page wise, according to the evidence which your lordship just read in course of argument, nothing has been said with regard to exhibit 1. So on the weakness of the defendants, we declared the right title interest of the plaintiff. So the plaintiff can stand on his own leg. It cannot depend upon the weakness of the defendant. This aspect. Now that is rightly decided by para 17, the appellate court judgment.
एक second, the learned counsel for the respondents while opposing the prayer of the appellant has submitted that the trial court has not at all considered the contents and contents of exhibit 1.
Contents and legality.
Contents, import and the legality and validity of exhibit 1.
Exhibit 1.
Rather, the learned trial court had decreed the suit on the basis of weakness of the case of the defendant.
Yes. Now note para 17 of the appellate court judgment.
The first appellate court in paragraph 17
yes,
has not only quoted the content of exhibit 1,
para 14.
para 14, has quoted the content of Exhibit
And
1
discussed in paragraph
and has
15,
discussed the same in detail and ultimately held in paragraph 15,
17.
that the said document cannot be, the said is at best a gift deed which was unregistered,
Yes. And it does not confer any right title interest
and it does not confer any right, title and interest
upon the father of the plaintiff.
upon the father of the plaintiffs.
Yes, in this. May I take your lordship's leave?
Yes.
I'm sorry not I have disturbed your lordship's court
नहीं,
proceeding.
इस सब में
Sorry,
टाइम
ma'am.
लगता है, लिखाने में बहुत टाइम लगता
इसमें 7-8 केस कर दिए.
है। हाँ, करिए। एक सेकेंड में 15 केस के बराबर तो है ही।
है.
तुम्हारा सारा सेकंड अपील डिसाइड हो जा रहा है माय लॉर्ड से, ये बहुत बड़ा चीज,
I just don't know.
बहुत बड़ी।
I don't want to dismiss the case on default. बस यही मेरा कोई फायदा नहीं है, जिसका जो लड़ाई है, जो झगड़ा है, फुल स्टॉप जरूरी है। So far as the first and second substantial question of law are concerned, both of them are related to Exhibit 1. The contents of Exhibit 1 has been quoted by the learned First Appellate Court in paragraph 14. This court has also gone through the Exhibit 1 as was available in the records received from the concerned court. The Exhibit 1 reveals that it was executed by Suraj Narayan Bid in favor of Kamlakant Bid, stating that Kamlakant Bid would take care of him during the lifetime and the property and Kamlakant Bid will have the exclusive title over the property, and the other 4 sons will have no right, title and interest over the property, and by virtue of this document itself, he says that the property is transferred to Kamlakant Bid. Although this document was termed in the plaint as family arrangement, and it was asserted that Kamlakant Bid was handed over this property in family partition. However, on the face of the document, Exhibit 1, it appears to create title in favor of Kamlakant Bid by his father Suraj Narayan Bid to the exclusion of his 4 sons. There is no consideration in terms of money involved in the document. However, this document by itself appears to transfer right, title and interest over the suit property, and also over the suit property exclusively to Kamlakant bid. This document can neither be termed as a document of partition, nor it can be termed as a memorandum of family arrangement, as it does not refer to any past transaction being recorded in this document. Rather, this document itself extinguishes the right, title and interest of the owner of the property sued in a line bid in favor of Kamlakant bid. This court finds that the first appellate court has rightly held that the document can at best be said to be a gift, transferring the right, title and interest over the suit property in favor of Kamlakant bid. And in absence of registration, the same cannot be taken into evidence. The learned court has also taken into, first appellate court has also taken into consideration that the plaintiff in his evidence has claimed that this document was a will. This court is of the view that such stand of the plaintiff, it was taken for the first time during evidence, stating that it was a will, is also not in accordance with law, in view of the fact that the said document Exhibit 1 does not reveal that it will take its effect upon death of Suryanarayan bid. The finding of the learned first appellate court in connection with this document has been given in paragraph 15 of the appellate court judgment. As rightly pointed out by the learned counsel for the respondents, the contents and the import of the Exhibit 1 has not been considered by the learned trial court. However, the consideration of Exhibit 1 by the learned first appellate court is in accordance with law. This court is of the view that the learned first appellate court has not erred in law in interpreting Exhibit 1. Consequently, the first substantial question of law is answered against the appellant and in favor of the respondents. So far as the second substantial question of law is concerned, this court is of the view that the learned first appellate court has rightly held that Exhibit 1 could be a deed of gift and has rightly held that the said document is not a memorandum of family arrangement. Upon going through Exhibit 1 as held above, this court is also of the view that the same is not recording of any previous family arrangement which had already taken place. Rather, the document itself is extinguishing right, title and interest over the property of Suryanarayan Pit in favor of Kamlakant Pit. Accordingly, the second substantial question of law is also answered against the appellant and in favor of the respondents. So far as the third substantial question of law is concerned, this court finds that the first appellate court has recorded that the defendant were in possession of the suit property since 1962 and there was no proof of tenancy with respect to the suit property. The learned counsel for the appellant has not pointed out any material to show that the finding of the learned first appellate court that the defendant were not tenants over the suit property but were owners of the suit property suffered from any misreading of materials on record or suffered from any perversity. This court finds that the learned first appellate court has considered the materials on record and recorded a finding that the defendants were occupying the suit property as owners and not as tenant. Consequently, the third substantial question of law is also answered in favor of the appellant, in favor of the respondents and against the appellant. So far as the fourth substantial question of law is concerned, there is no doubt that the defendants are the strangers to the family and were in possession of a specified portion of the property कौन सा सेक्शन है ट्रांसफर प्रॉपर्टी एक्ट का अनडिवाइडेड शेयर कैन आल्सो बी सोल्ड एज पर सेक्शन 44 अनडिवाइडेड शेयर बोला ना पार्टीशन तो नहीं किया एज पर section 44 of the Transfer of Property Act there is no legal impediment in transfer of property by one of the co-owners with respect to his portion of the property with respect to his share or interest over the property. And the buyer has got a right to enforce a partition merely because one of the co-owners of the property has transferred a portion of the suit property to the defendant. The same by itself does not, and by virtue of the same, it cannot be said that the defendants did not acquire any right, title and interest over the suit property. This is over and above the fact that the sale deeds were never challenged by the plaintiff in the suit. So far as the fifth substantial question of law is concerned, Santosh Kumar Bid, who is son of क्या नाम है इसका?
गोवर्धन अरे गोविंद
Son of who is son of Gauri Prasad Bid. Gauri Prasad Bid, who is the vendor, who is one of the vendor of the suit premises to the defendant. This court finds that merely because he has stated that Gauri Prasad Bid had not executed the sale deed and that the other brothers had left the suit. No, had not executed the sale deed, the same by itself has no bearing in the matter. The learned First Appellate Court has considered all the materials on record to come to definite findings, and therefore, merely on the basis of evidence of Santosh Kumar Bid, son of Gauri Prasad Bid, the suit of the plaintiff has not been dismissed. Rather, the suit has been ultimately dismissed by the learned First Appellate Court by considering all the materials on record. In view of the aforesaid facts and circumstances, this court finds no merit in this second appeal, which is apparently dismissed. कब का है ये 93 चल नेक्स्ट केस आप लोग बहस करते हैं ना, बड़ा कॉन्फिडेंस रहता है कि कम से कम फैक्ट सही से प्लेस होगा।
लॉ में भी कंसीड करना है,
लॉ में भी जो सेटल हो गया उसका तो क्या ही
आर्गुमेंट करना चाहिए, इसलिए करते हैं।
उससे मितुल 2-2 दिन आपका केस कॉल आउट करते हैं, आप रहते नहीं हैं।
किसी के सवाल केस में ऑनलाइन करते हैं।
आप तो ये ऑनलाइन हम तो ऑर्डर किए, आप डिफेक्ट तो रिमूव करना पड़ेगा ना, सर्टिफाइड कॉपी नहीं पाई थी। हाँ
1 week within 1 week।
हम तो कोई टाइम दे दिए, हमको याद नहीं होता
19,
जो टाइम दिए प्रेमट्री है
एक से एक पास हुआ फिर इसमें 6 होता है।
हाँ, ये क्या चक्कर है इसमें? सूट वैल्यू देखना है, क्या देखना है? अवॉर्डेड अमाउंट दिया है उससे नहीं चलेगा, क्लेम अमाउंट से चलेगा।
कोठी में
तो अवॉर्डेड वैल्यू लिख के दे दिया इंस्टेड ऑफ सूट वैल्यू। तो सूट वैल्यू वो क्या लिखी है इसमें, जो क्लेम रहा होगा उनका। तो यहाँ पे क्या क्लेम कर रहे हैं उसी हिसाब से अपना कर देंगे। सूट वैल्यू 5 लाख रुपए की है, कहाँ है, कितना है ये? क्लेम जो किया होंगे उसी हिसाब से होगा ना। यहाँ पे क्या क्लेम कर रहे हैं उसी हिसाब से आपका अपील में यहाँ पे क्लेम कर रहे हैं। लैंड एक्विजिशन है ना, लैंड एक्विजिशन देखिए जरा, filing number FA8903 of 2024. Office has pointed out that though the certified copy of the decree was sent for correction, but instead of providing the suit value on the decree, the learned court has provided the awarded amount. The learned counsel submits that unless the suit value based on the claim of the plaintiff is provided in the decree, it is not possible to quantify the court fees payable before this court. It has been also stated that the CC of the decree be sent back to the concerned court for correction. Considering the aforesaid submissions, let the certified copy of the decree be sent back to the concerned court for correction for the purposes of inserting the suit value in the decree. Along with this order, इस order के साथ भेजिएगा, तो लोगों को फिर समझ में नहीं आता है ना? Along with the copy of this order. Close this case on 22nd September.
Under heading for hearing item 2, second appeal 1 of 1999.
In this case, madam, we have filed the incident wherein we have stated that one respondent has died, madam.
Who has died and when?
Respondent number 12, namely Ram Narayan Bhagat, died madam on 13th November 2013.
तो इन्होंने तो अपना फाइल भी कर दिया ना सब।
इन्होंने अपना सब्स्टिट्यूशन फाइल कर दिया था। हमारा एक और प्रेयर था कि अर्लियर जो सब्स्टिट्यूशन हुआ था उसमें वन सी का नाम संगीता देवी हो गया था, लेकिन उसका नाम उषा देवी है। तो हम बोले थे कि उसी का एफिडेविट फाइल करने के लिए, तो उसका भी हमने एक एफिडेविट फाइल कर दिया था एनेक्सिंग हर ऑल सर्टिफिकेट्स ऑफ रिस्पोंडेंट नंबर 1 से। तो उसका नाम खाली थोड़ा सा चेंज करना था, उनका उसको उसमें हमको कोई ऑब्जेक्शन नहीं आया, उनका सब्स्टिट्यूशन को खाली रिकॉर्ड किया।
अब आइए फाइल किए थे इसमें।
हाँ, इसी हम अर्लियर आइए फाइल किए थे, उसी में हमसे
सब्स्टिट्यूशन अलाउ कर दें।
हाँ कर दिया उसको।
आपका वकालतनामा वगैरह सब डाला?
सब डाला सब, और जितना एयर्स है उसका वकालतनामा उसी आईए के साथ हम डालें।
ठीक, देखिए आईए नंबर 10751 of 2025 has been filed by the respondents under order 22.10A read with section 151 of CPC, bringing on record that the respondent number 12, namely Ram Narayan Bhagat, has died on 13th of November 2013. Giving the names of legal heirs and successors. A prayer has also been made that the name of respondent number 1 within bracket A be deleted, who died on 4th of June 2021, leaving behind our legal heirs who are already on record as respondent number 1B, 1C and 1D. A further prayer has been made that the name of respondent number 1C, namely Sangeeta Devi, be ऐसे कैसे सब्स्टिट्यूशन होगा?
सब्स्टिट्यूशन हम खाली नाम बदलने के लिए बोल रहे हैं। अर्लियर सब्स्टिट्यूशन हो चुका है। सब्स्टिट्यूशन वाज डन बाय नॉट बाय
just a moment. Be substituted as Usha Devi instead of Sangeeta Devi. He has submitted that the all credentials of Usha Devi with her parentage etc. has been brought on record by filing a supplementary affidavit in this case. क्या लाए हैं उनका?
उनका सब सारा डॉक्यूमेंट ले आए, मैट्रिक का सर्टिफिकेट और सारा सर्टिफिकेट।
The matriculation certificate has been filed along with the supplementary affidavit showing her father's name as
लक्ष्मी नारायण हो,
Lakshmi Narayan Sahu.
साहू है, भगत साहू है जो भाई, और उसका हस्बैंड का भी ले आया, जो ये आधार कार्ड ले आया है कि अभी वो दूसरा।
नहीं ऐसे नहीं होता है, ऐसा नहीं होता है, नहीं होगा,
छोड़ दिया जाए उसको, वही रहेगा।
जो है सो है, वो सब हम नहीं अलाउ करेंगे।
ठीक है। क्योंकि ये उनकी तरफ से आया था पिटीशन, उसी को अलाउ हुआ, उसको इसको ध्यान हम लोग नहीं दिए।
किनकी तरफ से आया था?
अपने डिफाइन किए थे जो सब्स्टिट्यूशन हुआ, हम लोग तो
तब ध्यान नहीं दिया।
बाद में अभी अभी भी उन लोग पॉइंट आउट किया जो ऑर्डर लेके आया था, तो हम लोग कैसे कोशिश करेंगे कि उषा देवी हो जाए, नहीं तो ठीक है।
इसको नहीं चेंज करेंगे, जो सब्स्टिट्यूशन हो गया सब, 1C को नहीं चेंज करेंगे।
ठीक है।
The learned counsel for the appellant has submitted that IA number 1147 of 25 has been filed for with a petition for condemnation of delay in filing the substitution of respondent number 12. The names and legal heirs and successors have been mentioned, which is matching with the details given in IA number 10751 of 2025. He submits that immediately after getting information. The petition for substitution has been filed and the case has remained pending before this court since 1990. Considering the aforesaid facts and circumstances, the IA number 1147 of 2025 seeking substitution of respondent number 12 and deleting the name of respondent number 1 within bracket A is allowed. The counsel for the appellant is directed to carry out the necessary corrections, amendments in the cost item during the course of the day. IA number 10751 is closed. आपका IA अलाउ कर दिया, इनका क्लोज कर दिया, और क्या बचा है इसमें?
कुछ नहीं।
Ready for hearing. Ready for hearing.
Ready for hearing. That's it. देखते हैं क्या है क्वेश्चन ऑफ लॉ. With the consent of the counsel for the parties, the hearing has commenced.
आज कर सकते हैं, हमको कुछ कहे कि इनका कुछ है नहीं, बिकॉज ये
अच्छा कुछ है
बस
I will argue this next week lordship.
Next week,
Next week any day lordship. सोमवार मंगल
उस
बुधवार
वक्त कौन मर जाएगा, कौन
नहीं
जीत जाएगा, कौन
सब हम लोग रहेंगे.
हम तो उसको नहीं गारंटी
नहीं पूरा गारंटी है.
मेरा कोई गारंटी नहीं.
सोमवार मंगल किसी दिन भी रख दिया जाए, हम तैयार हैं.
अच्छा थोड़ा सा सुनेंगे क्या क्या है, उसके बाद एडजर्न करेंगे. बिना सुने नहीं एडजर्न करेंगे.
ठीक है.
ठीक है. 1:30 बज गया है, सेकंड हाफ में आइए.
सेकंड हाफ में
और सेकंड हाफ में दूसरा
सेकंड हाफ
मैच.
तो ऐसे भी वो चलेगा।
अच्छा ठीक. ऐसा करिए, विद द कंसेंट ऑफ द काउंसिल फॉर द पार्टीज पोस्ट दिस केस फॉर फाइनल हियरिंग ऑन
नेक्स्ट वीक रखते हैं।
नेक्स्ट थर्सडे. थर्सडे छुट्टी है क्या?
थर्सडे
थर्सडे छुट्टी है? हाँ
नहीं
थर्सडे
फाइनल
इसी हेड में तो आता है एकदम टॉप ऑफ द केस। क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ है, जरा देखिए कितना टाइम लगेगा।
Order number 7, Lordship. Para 4, Lordship. The most important substantial question number is 2, Lordship. Is the suit for permanent injunction maintainable in the facts and circumstances of the present case, where the no declaration of title has been sought for in the complaint, Lordship? He is only praying for injunction. No relief was claimed for declaration of title. There is a direct judgment of this Honorable Supreme Court.
सुनिए आप,
हाँ,
सुनने
उसमें
का बहस।
जजमेंट है कि अगर मेरा टाइटल एकदम क्लियर टाइटल हम प्रूफ कर देते हैं कोर्ट में, तो आई कैन ओनली प्रे फॉर इंजंक्शन। देयर इज जजमेंट।
तो टाइटल पे कोई डिस्प्यूट नहीं है तो क्यों क्लेम
डिस्प्यूट
करेंगे?
है, डिस्प्यूट है। हाँ, डिस्प्यूट है तो सूट का ही लिखा है। सूट ही खुद ही
हम अगर फैक्ट इसमें स्टेट करते हैं कि 3 भाई का शेयर था, जो इनका कहना है कि ये जो है सुपरवाइज दिस एप्लेटिस कर सकते।
समझ गया कितना बहस करनी है।
छोटा। और दूसरी चीज, पॉइंट को डिटरमिनेशन नहीं हुआ है।
उससे क्या मतलब है? सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है ना, सब
एविडेंस भी नहीं किए हैं, एविडेंस भी डिस्कस नहीं हुआ, खाली सबमिशन लिखा
आपको
हुआ
सिर्फ
है।
रिमांड करने में मन लगता
नहीं,
है।
सबमिशन खाली
एक ही चीज चाहिए कि इसको रिमांड
नहीं, रिमांड के लिए नहीं, सबमिशन खाली लिखा हुआ है।
कुछ भी नहीं। अब जो सब्सटेंशियल क्वेश्चन ऑफ लॉ
हाँ, ठीक
बना
है।
है उसी पे डिसाइड करेंगे, ठीक है? नहीं तो बाकी रिकॉर्ड यहीं पर है, इसी पे डिसाइड करेंगे।
ठीक है,
ठीक है, समझ लीजिए हम ही ट्रायल को।
ठीक है।
वही एक इशू है जो उस पर लॉ सेटल्ड है कि अगर टाइटल क्लियर है तो किया जा सकता है।
नहीं, टाइटल इनका क्लियर नहीं है।